Before today's hearing even begins, it already feels like the court is dealing with much more than a routine request for an adjournment. What starts as a scheduling issue quickly unfolds into allegations that could completely change the direction of this case. Prosecutors aren't simply asking for more time because a witness is unavailable. They're telling the judge they believe the defendant may have actively interfered with the justice system itself. According to the prosecution, while out of custody, the defendant allegedly made numerous phone calls to the alleged victim, despite a strict no-contact order. Those calls weren't described as casual conversations. Instead, prosecutors claim they contained instructions about what the victim should tell investigators and even suggest that those conversations influenced her changing version of events. If that's true, this hearing suddenly becomes about far more than the original charges. It becomes a question of whether the integrity of the judicial process itself has been compromised. On the other side, the defense paints a very different picture. They describe a young man with no prior criminal history, supportive parents who have stood by him every step of the way, and someone who has already experienced the harsh reality of spending time behind bars. They'll argue that he's trying to rebuild his life through school, employment, and family support, and that keeping him out on bond gives him the best chance to continue moving in the right direction. But here's where this hearing becomes fascinating. The judge is caught between two competing responsibilities. One is to give defendants every reasonable opportunity to prove they can follow the rules. The other is to protect victims, preserve the fairness of the court process, and make sure no one attempts to manipulate witnesses or influence testimony. Those responsibilities don't always point in the same direction. As you watch, pay close attention to the judge's questions, the prosecutor's allegations, and the defense attorney's efforts to keep his client on bond. You'll also notice how the defendant's own statements affect the court's perception of him. By the end of this hearing, one decision will determine whether he walks out of the courtroom or back into custody. The biggest question is simple. Has the court lost confidence in him, or does he deserve one more chance? Let's find out.
What are we doing?
Your Honor, as I explained at the bench, people are seeking an adjournment. Quite a few things have come up. The evening with the and I mentioned is that the officer in charge is informed me at the point that he's ill, cannot be here to testify. We would need his testimony here today. Your Honor, there's also the issue of the jail calls that were made. This defendant, while he was in custody, called the victim multiple times. The content of those calls are highly concerning to the people. They suggest witness tampering. The fact that she is not here today kind of completes the concern we had that his calls and his communication with her have had the effect that he intended them to have. Specifically, we have concerns because he gave her a story of what to come and tell the prosecutor's office. She did comply with that, and as counsel is aware, and courts now aware, she has indicated to us what I would call a recantation, but certainly a different version of events matching what this defendant instructed her to do. There's a lot more to it, including statements he made, telling people that the victim was not coming to court and so on. With all of that, Your Honor, we have concerns, so we need to further look into that. Those calls were shared with the public defenders already. I resent the very specific call to defense counsel this morning. I'm going to be listening to those a little more closely. I'm considering witness tampering charges moving forward. And we do have concerns about this defendant being out of custody and the behavior he might have engaged in and may continue to engage in, and making sure the victim does not appear to testify against.
Sure.
Let's pause here because the defense has shifted the focus away from the allegations and toward the person sitting at the defense table. Rather than arguing the facts of the alleged witness tampering, counsel is emphasizing the defendant's background, his supportive parents, lack of criminal history, and efforts to improve himself through education and employment. That's a common strategy during bond hearings. The goal isn't necessarily to prove innocence, but to convince the judge that the defendant can safely remain in the community while the case continues. However, notice what's happening beneath the surface. The prosecution is talking about protecting the judicial process, while the defense is talking about rehabilitation and family support. Those are two very different conversations, and the judge now has to decide which concern carries more weight. What do you think? Should strong family support outweigh allegations of violating court orders, or is trust already too badly damaged?
with respect to the people's adjournment request, at this time, we have no objection to that.
Okay.
And I had an opportunity to speak with my client, Mr. Larry, and Mr. Larry Sr., who is present in court today. Miss Larry was here earlier, and both of his parents really have been calling off work, making every effort to be at all of their sons' court dates. I
recall that the last time he was here, they were here. I recall that. Okay.
And in addition to that, I know back on April 27th, Miss Larry wrote a character letter to the court, which I know the court can't consider at this juncture. However, that was sent to counsel, and I reviewed that. And Miss Larry speaks highly of her son. And I think, you know, insofar as Mr. Larry's at a fork in the road, they are committed to make sure he takes the right path and comes out of this continuing the positive work he was doing before arrest in this case. And I would note that this is Mr. Larry's first interaction with the criminal justice system, as far as I can see on his criminal history. When he was released from custody after spending about 30 days in jail, he was placed on home confinement and lives at home with both of his parents. During the time he was in custody, you know, he had to deal with the consequences of being in custody, which included losing his job. His parents want him to get a new job, and I talked to Mr. Larry about essentially scheduling an interview, talking to his tether agent, and seeing if there can be an accommodation made for him to go and do an interview, which I know, you know, if that needs to be done by stipulation or order, I know it's something that has been accommodated in the past. Mr. Larry's enrolling in school. He's Washtenaw County Community College for either a CDL, HVAC licensure, but he's trying to get higher education. And I think since he's been out on home confinement, he's certainly not been violating the court's orders.
Well, but the problem is, I don't know that. That's my great difficulty.
When I talked to Mr. Larry's parents, I was very specific about what the court's orders are, including no contact and what no contact means. They ensured me that they're not going to let it happen under their roof. And as far as he's on home confinement, I mean, what they relayed to me is essentially the court's home confinement tether at this point is he'd be on home confinement anyway. They're making sure that he's staying on the right path. They don't want him to end up in jail or, you know, at the end of this case to be worse off than he was coming into it. So I'm going to ask the court respectfully to consider continuing his bond at this time. Come back on the next date. I've already talked to Ms. Tana about resolving this case. I'm going to talk to my client at length about resolving this case, which, you know, what we pondered does entail further court supervision. But as far as abiding by the court's orders, you know.
This is the turning point of the hearing. Listen carefully to the judge's wording. He isn't criticizing the defendant's parents. In fact, he's openly acknowledging that they seem caring, supportive, and genuinely invested in helping their son succeed. The problem, according to the judge, isn't the family. It's whether the defendant himself has earned the court's trust. That's an important distinction. Judges frequently rely on family members to help supervise defendants while they're released on bond. But if the court believes the defendant intentionally ignored previous conditions, even the strongest support system may no longer be enough. Trust is incredibly valuable in pre-trial release, and once it's broken, rebuilding it becomes extremely difficult. You can also sense the judge becoming personally disappointed. He mentions giving the defendant a huge break previously, suggesting he took a calculated risk by allowing release despite earlier concerns. Now, he's questioning whether that decision was a mistake. Have you ever seen a moment where a judge sounds less angry than disappointed? Sometimes disappointment carries even more weight than frustration.
Mr. Larry and his parents are going to make sure that continues on.
My difficulty is that I believe that his parents have all the best intentions of the world and are probably the most disappointed by all of this. But I myself am very disappointed when I find as I told you, counsel at the bench, I gave him a huge break the last time in letting him out, knowing that there were phone calls. That's come back in certain respects to bite me because I now know that these weren't just, not to minimize them necessarily, but not just context to the alleged victim saying whatever. He was to manipulate the system. I don't even know what's going through his head.
Scared.
Well, he should be, because he's got me right now. He should be scared. Because the grand reality of it is that I can't trust you to be out. I don't know what you're doing. Understand what I have here. I let you out. I gave you the opportunity. You create some story that the no. No. Because you want to believe in him, that's fine. I want to believe in him too. I gave him an opportunity and he has messed this up and is now facing potentially another felon. And I don't know that you even understand that, young man. No, you don't. Why would you put yourself in a position to pick up another felon? You weren't even supposed to be communicating with this person at all. But then you communicate and you go even further to concoct some story. And now and here's what you have to understand from that. From that, you concoct that story, and then I have no victim here today. She not only takes the story that you give her, communicates it to authorities, then doesn't show.
Your Honor.
The emotional temperature in the courtroom has just skyrocketed. The judge is no longer discussing hypothetical concerns. He's connecting the alleged phone calls directly to the victim's absence from court today. From the court's perspective, that's an extremely serious issue because the justice system depends on witnesses being able to testify freely, without pressure or influence. It's important to point out that these are allegations being discussed during the hearing, not findings of guilt on new charges. Even so, the judge is evaluating whether those allegations affect the defendant's eligibility to remain free on bond. That's a very different legal question than whether someone is ultimately convicted of witness tampering. Notice how every alleged action builds upon the previous one in the judge's mind. The no-contact violation leads to concerns about influencing testimony. The alleged influence leads to concerns about the victim's absence. Together, they paint a picture that makes the court increasingly reluctant to extend further trust. At this stage, do you think the defendant still has a realistic chance of keeping his bond?
Go ahead if you think it's advisable to say something to me, because I am livid right now.
Takes me on the phone with them. What was she? Agreed, shut him. Tell me now. Your Honor, I would ask the court to consider the fact, since Mr. Larry's been released on home confinement, I think almost right away, he got into some level of domestic violence programming. I spoke with Ms. Tana. There's a program that we are both familiar with that I want to refer him to immediately, and into addressing, the underlying allegations here. It addresses those of issues in terms of, it was a bond violation trying to impact the outcome of proceedings, those kinds of things. And I want to make sure that, Mr. Larry's getting to the resources he needs. I think If he's at home on home confinement with his parents, I think he's in a better.
How do I know he's not contacting the victim?
Well, when I spoke to his parents, Your Honor, they advised.
I don't doubt that they're going to do the best they can. I trust them. I don't trust him.
Not contact the victim.
Mr. Warren Green, what kind of choices is available in jail if he wants to start that? Might be advised.
Contact the victim. Your Honor, my client would just assure the court he's not going to violate any court orders, including the no contact
He
order.
assured the magistrate of that after his arraignment.
The defense is making one final effort to explain what happened, arguing that the defendant's conduct was driven more by immaturity and panic than by calculated criminal intent. Counsel describes him as nervous, inexperienced, and overwhelmed by his first encounter with the justice system. That's a reasonable argument for mitigation, but it's running into a major obstacle. The judge responds with a simple but devastating question. What exactly is confusing about a no-contact order? That cuts straight to the heart of the issue. Courts generally expect defendants to understand straightforward conditions like, do not contact the alleged victim. Whether someone is scared, stressed, or inexperienced doesn't necessarily excuse violating a direct court order. This exchange perfectly illustrates how two legal professionals can view the same behavior differently. The defense sees poor judgment. The judge sees a deliberate choice. And in bond hearings, those competing interpretations often determine whether a defendant keeps or loses their freedom.
Understood. I was nervous and she was pregnant, so this is my first time, Your Honor.
What?
Your Honor, I think my client's expressing that it is his first interaction with the justice system. He was nervous about the ultimate outcome of this case. It's a big.
What confusion do you have of do not contact this person?
I don't think it's confusion, Your Honor. He admits to violating the court's orders with respect to the no contact order. I think it's naivety, and I think it's him trying to change the outcome of this case. I understand that as far as it's a bond violation. I'm not sure if it rises to a matter where we're dealing with forfeiture by wrongdoing at this point. So I don't want to go too far down that road in terms of what I address, but you know, he knows that's a possibility at this point. And at this point, we're kind of shifting gears and talking to the people about a resolution that involves significant domestic violence programming.
And you know, for the record, if I may, at least 38 calls were made to the victim using other inmates' pins. So being naive, that to me doesn't indicate a naive person. That is deliberately working to kind of fight the system, trying to get out of it. And I agree, trying to affect the outcome of this case. And that's exactly what we're trying to prevent.
And see, it's that behavior why I can't trust you.
Staying here.
Because I don't have a doubt your parents are going to put everything they can possibly put in place to try to make sure you don't mess this whole thing up. But we do the same thing in the jail by giving you a PIN number. And what do? You try to circumvent and go around that whole thing. Then you try to concoct some story, and that comes back. And now you're going to potentially face another felony, as well as proceed without the victim on this case.
The prosecution has now introduced one of the most damaging details of the hearing, the allegation that nearly 40 calls were made using other inmates' PIN numbers. If true, that suggests more than an impulsive mistake. It suggests repeated efforts to work around restrictions that were already in place. Again, it's important to remember that these statements are allegations presented during the hearing, not criminal findings. But bond decisions are based on risk assessment, and judges are allowed to consider information that affects public safety, witness protection, and confidence that court orders will be followed. Listen to the judge's repeated use of one word, trust. That's really what this hearing has become about. The original charges are still important, but the immediate question is whether the defendant has shown the court he can obey its rules while awaiting trial. Right now, every new allegation seems to make that answer more difficult for the defense.
You don't even begin to understand what the heck you've done. And if you had just stuck by the rules, we wouldn't even be in this boat. I don't need to have this conversation with you. I don't need to try to make sure that the victim in this case can proceed with this case if that's what she so chooses to do.
Okay. 30 days. Well, that I did. So already mistakes were already made. I was 30 days sitting there.
At this stage, the defense is making what is essentially its final appeal for mercy. Notice that the argument has shifted away from disputing the alleged bond violations. Instead, counsel is asking the judge to focus on what happens next. The attorney points out that spending time in jail has already had a significant impact on the defendant and argues that this experience has become a wake-up call. He emphasizes that his client now understands the consequences of violating court orders and is unlikely to repeat the same mistakes if given another opportunity. From a legal standpoint, this is known as a mitigation argument. Rather than denying what happened, the defense is asking the court to believe the defendant has learned from it. The challenge, however, is that mitigation only works if the judge believes future behavior will be different from past behavior. That's exactly where this hearing has stalled. The judge isn't questioning whether the defendant regrets his actions today, he's questioning whether he can trust him tomorrow. If you were making this decision, would you give someone one final chance after multiple alleged violations, or would you decide that enough chances had already been given?
Your Honor, I'd ask the court to consider that the time Mr. Larry spent in custody did have an impact on him. And moving forward, if the court is gracious enough to consider continuing his bond at this point, if he's going to comply with any of the court's orders, but that's going to be a constant reminder as to what happens when he does not. And, I referenced naivety earlier. He didn't think he was going to get caught, and he did. And I think he knows at this point, and his parents well know at this point, if he's caught in violation of his bond conditions whatsoever, he's on thin ice, and it's going to land him back in jail. If it does,
I don't know if he cares, Mr. Warren. I really don't know if he cares. Because if he had cared, he would not have done what he did.
Your Honor, he's been working on himself a lot. This arrest, hopefully in the long run, going to be the biggest turning point in his life. And that's his sentiment he's expressed to me this whole time. He's got two people that really care about him, that are really going to make sure that he stays on the right track if the court's gracious enough to continue his bond at this point.
The bond that was posted for you was not your money, was it?
No, sir.
It was your parents' money.
My brother and my sister.
This exchange reveals something that often gets overlooked in criminal cases: the impact on the defendant's family. The judge points out that the bond wasn't even posted with the defendant's own money. His family stepped up financially, invested their time by attending every court hearing, and stood beside him when many people might have walked away. That's why the judge's comments carry so much emotional weight. Notice that the court isn't criticizing the family. In fact, the judge repeatedly acknowledges their commitment and sincerity. His frustration is directed at the defendant because, from the court's perspective, he failed to honor the trust that his family and the court placed in him. It's a reminder that criminal cases rarely affect just one person. Parents, siblings, spouses, and children often carry emotional and financial burdens long before a verdict is ever reached. This moment also highlights a reality of the justice system. Strong family support can be a powerful factor in bond decisions, but it cannot erase conduct that causes the court to lose confidence. Do you think the defendant truly appreciated everything his family was sacrificing for him, or did he only realize it when it was almost too late?
Then you got your family here. Everybody's trying to do everything for you except you. Here's what the problem is, counsel. I've got to figure out, and I've got to give the people time to figure out whether why this victim isn't here. But until such time, I mean, do you know how long it may take people to figure out if they're going to bring additional charges against him?
Your Honor, I have no problem reviewing it today. I do need the OIC to do some. So I would ask for it.
I'll adjourn the preliminary matter to May 26, 2026, 9 a.m. before me. That's in person. At this point in time,
The judge's tone has now shifted from frustration to finality. Listen carefully to what he's saying because it's about accountability, not punishment alone. He tells the defendant, "Make your bed. You got to lie in it." That's a phrase often used to explain that our own choices create consequences that can't always be undone. What's striking here is that the judge doesn't appear to enjoy making this decision. He even says he doesn't want to send the defendant back to jail unnecessarily. Instead, he repeatedly explains why he believes he has no reasonable alternative. In his view, the alleged violations, the concerns about witness interference, and the uncertainty surrounding potential additional charges have made continued release too risky. This is an important distinction. Bond isn't intended to reward or punish someone. Its purpose is to ensure public safety, protect the judicial process, and guarantee that court proceedings can move forward fairly. Once the judge concludes those goals are no longer being met, revoking bond becomes a very real possibility. At this point, can you see any argument that realistically could have changed the judge's mind?
Young man, just gonna have to understand. You make your bed, you gotta lie in it. I'm not gonna don't look at me like this is you.
Right.
Your family put up their money. They did that. Your parents are down here with all their time and everything, trying to stand up for you. And you did this.
Before I already made the mistakes, Your Honor. It was way before that. After I got put in there for 30 days.
Here's the problem. You've interfered with the whole system. That's the problem. You should have never done any of this. Ever. So if the people would do that, review it, get in touch with counsel, but this time I'm going to revoke his bond. Defendant's remanded.
And there it is, the decision everyone has been waiting for. The judge officially revokes the defendant's bond and orders him remanded into custody. But listen closely to the explanation because it's more nuanced than simply saying, "You're going to jail." The judge explains that prosecutors still need time to determine whether additional charges related to the alleged witness tampering will be filed. Until those questions are answered, he believes releasing the defendant would create unnecessary risks. At the same time, he also tells the prosecution to move quickly because he doesn't want the defendant sitting in jail any longer than necessary if those issues can be resolved. That balance is an important part of judicial decision-making. The court is trying to protect the integrity of the legal process while also recognizing that defendants retain important rights before trial. Even after revoking bond, the judge leaves open the possibility of reconsidering release once the investigation becomes clearer. It's a reminder that court rulings often evolve as new evidence and new circumstances emerge.
I will consider his release if the people can figure out exactly where they're going to go with this and have the OIC. I'd ask them to hurry up and do it. I don't want to leave him in jail, but he's made his bed and that's where he is now. But I got to figure out that everybody else in this whole system is safe, not just you. You can take it. Dad, don't do it.
What began as a routine request to adjourn a preliminary hearing ultimately turned into a hearing about trust, accountability, and the integrity of the justice system. Prosecutors informed the court that they were investigating allegations that the defendant repeatedly contacted the alleged victim despite a no-contact order and may have attempted to influence her statements. Those allegations, combined with the victim's absence from court, became the central issue of the day. Throughout the hearing, the defense highlighted the defendant's clean criminal history, supportive family, educational goals, and willingness to participate in counseling and domestic violence programming. His attorney argued that he deserved another opportunity to remain on bond under strict supervision. The judge acknowledged the family's dedication and made it clear that he believed they genuinely wanted to help. However, the court ultimately concluded that the defendant's alleged actions had undermined the trust necessary for continued release. As a result, the judge revoked the defendant's bond, ordered him back into custody, and adjourned the case while prosecutors determined whether additional charges related to witness tampering should be pursued. The judge also indicated that he would consider revisiting the bond decision once those questions were resolved, showing that the matter is not necessarily closed but will depend on future developments. This hearing serves as a powerful reminder that bond is built on trust. When a court believes its orders have been ignored, or worse, that the judicial process itself may have been affected, that trust can disappear very quickly, regardless of a defendant's family support or future plans. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'd love to hear your opinion. Did the judge make the right call by revoking the bond, or should the defendant have been given one final opportunity? Let us know below, and we'll see you in the next courtroom breakdown.